I hope everybody had a great holiday season. We appreciate you joining us, and that your 2017 is off to a great start. This month's topic is, for the most part, a lot of people consider employee resignations to be fairly simple, and they all consider this to be, a no-brainer issue. And for the most part, that is the truth. So this webinar is going to be based on dealing with the 1 to 5% of your resignations that go sour, and these individuals file an unemployment claim for whatever reason. Most people who file an unemployment claim or a resignation is based because they've gone off to work at other places and they've lost that job for some reason. And those individuals, then when they file that unemployment claim against that other last employer that's not your organization, you get that unemployment claim because you still have liability in the base period. So the point of this, and we almost, those are the type of unemployment claims that we almost always avoid because obviously there's not an eligibility issue attached to those unemployment claims in most cases. The point of this webinar is going to be based on those resignations that where you're the last employer, and generally speaking there is a root cause associated with the reason why they've quit. So the first thing is, what do they determine is a resignation? The definition of a resignation is that the first overt act of creating the separation must be created by the claimant. It must have been made by the claimant through an action or some kind of verbal notification, written notification, whatever it might be, or even it can be something as simple as no notice at all, no information. Sometimes is as equally as important as all the typewritten letters that you may get from an individual. So that's the first thing, is when you're thinking about voluntary separations, that first overt act to create the separation has to be conducted by the claimant. The separation is voluntary in nature through either notice or actions by the employee. So either they've given you written or verbal notice, or something about their actions. For the classic case, obviously, is the no call, no show. They've done something that has construed their intent to resign their position. Okay, so those are the next two things. And then the claimant must show good cause attributable to the employer or the employment. And we're going to talk about what good cause is here in a minute. But when an individual quits the job, the legal burden is on the claimant to show this good cause definition that we'll talk about here in a second. But the practical burden is placed on the employer to show that the claimant did indeed resign. As you probably recall from our other webinars, this is a system that is inherently biased in favor of the claimant. So even though there is a legal burden on the claimant to show that they quit because of the good cause issue, the practical burden is that the state is going to make the employer show that they did everything they could to resolve an issue before that claimant quit and filed an unemployment claim. So what is good cause? Okay. Well, in the case of a resignation, the claimant must show the following. They have to show that made every effort to preserve their employment. A perfectly good example of that would be if an individual is alleging that they quit due to harassment or discrimination, they have to show that they gave the employer the opportunity to resolve the issue before they took the drastic act of quitting. Okay, so that would be one of the burdens that they have to show. They have to give the employer an opportunity to correct the issue. So either they have to do an investigation, they have to address the issue, they have to do some form of they have to have some form of resolution process in place in order to try to attempt to reconcile what the claimant is saying versus what the actual practice is. So in this particular case, as we're saying with the harassment issue, They have to give the employer the opportunity to conduct that investigation, come to their findings. They don't have to like the findings, okay? They just have to give the employer the opportunity to resolve the issue. Now, in this particular case that we're using an example of, if the claimant doesn't like the outcome of the investigation, that doesn't automatically establish good cause. Just because they allege harassment or discrimination and you conduct a thorough investigation and find that you can't substantiate their argument or their allegations, that doesn't mean that that's automatically going to shift to good cause. You just have to be able to prove that you did your due diligence in addressing their problems. One of the burdens that they have to show is that the situation was so dire that a reasonable person would have resigned. It can't be trivial. It cannot be inconsequential. It has to be shown that their only alternative left to them was that they had to quit. Obviously, if they are in a situation, using our previous example, that if they are being harassed and the employer doesn't do their due diligence and doesn't correct the problem, then they could show that that would be good cause for quitting because they addressed their concerns with the employer and then the employer didn't do anything about it to resolve the issue. So that would allow them to quit for good cause attributable to the employer or the employment. So that would be an example of it. A combination of these attempts to preserve their job and the severity of the situation is going to help the state determine whether or not there is or is not good cause established to qualify them for unemployment benefits. Examples of good cause. As I mentioned, harassment or a hostile work environment. These are probably, if you had to pick the first one that we see the most often as far as alleged good cause, it would be harassment or a hostile work environment. The next one would be some kind of discriminatory or other illegal practices. Obviously, discrimination is illegal under federal law. So you can't, the individual may allege discriminatory practices, but that doesn't mean that it's necessarily the case. Again, they have to show that they took their concerns to management and allowed management to come to a reasonable alternative or resolution to that problem. Illegal practices would generally apply to for them to be asked to do something that's illegal. Wage and hour issues are a classic one. They're very prevalent right now. People being asked to work off the clock or receive time in lieu of overtime, stuff like that. If you're asking that individual to do that type of thing, then those individuals resign immediately and they say we're not going to do that. That's likely going to be considered good cause. This is the one that you see the most of, and that is a significant change in the employment status. Whereas harassment and hostile work environment is often the most alleged that we see, they rarely result in the claimant being awarded unemployment benefits. Generally speaking, the one that we see awarded unemployment benefits is where the claimant can prove that there has been a significant change in the hiring agreement. And one of those is changes to salary or structure or pay. Depending upon the state that you're in, demotions might not be considered to be a good cause issue. For example, in Kansas, if you are demoted from a managerial position to a rank and file position and your pay is adjusted accordingly and you resign, Kansas law says that is not good cause anymore. It doesn't apply because a reasonable, they give the employer the right to make modifications to their work staff as they see fit, and it does not give a rational person would not choose complete unemployment over a reduced salary. Other states do not have that. It's based on more of a threshold figure. And that threshold, depends on which state you're in. Generally speaking, most states, unless they have a specific statute like Kansas does, 20% reduction in pay is going to be what's going to catch the attention of the state examiner or deputy. Okay, the same would apply for any reduction in hours. The reduction in hours is generally speaking a 20% reduction. That would apply in Kansas and other states that have the exemption for demotions as well, because that's not, generally speaking, you don't usually reduce hours of a salaried managerial employee. So generally speaking, this is going to apply to hourly employees. If you have a part-time employee who has a certain number of hours and you reduce those hours and they quit, one of the thresholds they're going to look at is whether or not the what was the percentage of the reduction and how long was the percentage of the reduction for, etc. So there's a lot that goes into proving good cause, and most of it's very weighed heavily in favor of the employer. For example, using my example as reduction in hours, say it's a seasonal employee, they're not going to put a lot of weight behind the argument of the reduction of hours as being good cause if it's only a temporary 1 or 2 or 3 week reduction. If it's something that's going to be indefinite, then that is going to have a lot more weight in deciding that there was good cause, as opposed to being a temporary or with some form of determinate length of time that the reduction is going to occur. So what is not good cause? Well, good cause is not general dissatisfaction with the employment. If you don't like your job and you don't like what you're doing, and and you're having a bad day and you quit, that is not going to be good cause. It is not general dissatisfaction with the work. Disagreement over disciplinary actions is also not good cause. The employer, as long as they're being fair and consistent in their application of their policies, has the right to reprimand and discipline their employees as they see fit. So as long as you're meeting all your consistency criteria and you're making sure that you apply your policies in a fair manner, disagreement over a disciplinary action is not going to be considered good cause about 99% of the time. Transfer of a work site or a change in job description, if you're notified at the time of hire, is not going to be good cause. Most employers have something in their handbook, generally speaking, that says you reserve the right to modify or change job descriptions as necessary. It could be, it doesn't have to be a grandiose type of policy or something like that, but generally speaking, if you inform individuals that you reserve the right to make adjustments to their work duties and work schedules as business needs arise, then you're not going to run in the danger of having an individual quit for good cause. So you might want to look at your policy handbooks and consider that. Job descriptions, the same thing. You might have something in your job description that says other duties as needed or something to that effect. The employee, if you're asked them to do something that's reasonable and within the restraints of your business operation, they're not going to be able to construe that as good cause. So if you ask the cashier to take out the trash one time because you're overwhelmed, you need some extra help, and they're just standing around, and they tell you that that's not their job, well, it is, because you're saying it is. So just keep that in mind, that you do have the right to adjust and to modify job descriptions as you see fit. The transfer of a work site generally applies to individuals who might be of a managerial duty. I know a lot of employers, when they hire managerial employees and they are a multi-work site operation, they might tell these employees that they reserve the right to transfer them from a store to location or store to store. The factor that will go into the transfer of the work site will be how far is the work site from their current work site and what personal issues may affect the transfer. Okay, so if you are saying here in the Kansas City area, I want to transfer you from location A to location B, and there's a 7-mile difference between the two locations, there's going to be zero issues with that for when it comes to good cause, because that's a reasonable transfer. If you say you're going to transfer that individual from Kansas City to Omaha, now that might become more problematic because you're opening up the state to ask other issues. And those other issues might be, what is their job status? Do they have children? Do they have a spouse who's tied to a particular employment, et cetera, et cetera. So that one's not quite as clean as the job description, but generally speaking, if you notify them at the time of hire that that's a possibility, you're going to have a very strong case because they accepted that as a condition of employment. Good cause cannot be established if the issue has never been reported to management. When I said that the alleged reason for good cause is often harassment, that is what the claimant tells the state more often than not when there's an issue. Oftentimes it comes back to the claimant has to admit that they never raised this complaint before they resigned. They have to raise the issue prior to giving the resignation. If they don't, then all bets are off for them. They have to give you the opportunity to resolve that, as I mentioned before they give you the resignation. So a couple of strategies that I want to make sure that you follow here. The first one is pretty obvious, and that is get a letter of resignation whenever possible. When I was doing this in a practical sense many years ago, if an employee came in and told me that they were resigning, the very first thing I would do is put a piece of paper in front of them and say, please put it on paper. I need to know. That gives you a couple of clues right off the bat, and that is most reasonable people will give you a letter of resignation. If they're quitting for other employment and there's no problems, they're going to give you that letter of resignation. They'll probably sit down right that moment and give it to you. If they refuse to give you a letter of resignation, that should be your first red flag. Okay, there's something more to this story, because again, reasonable people who are leaving on good terms are going to not burn a bridge, and they're going to give you notice, and they're going to give you an explanation as to why they're quitting. If the claimant is, if the employee is not available, I should have said employee, not claimant, but if the employee is not available, consider sending them a certified letter. This doesn't mean that you have to do this for every individual who just doesn't show up to work or doesn't report or whatever. You will want to reserve this to perhaps issues that to employees who are having major issues. A perfect example of that would be an individual who has a workplace injury but is refusing to report to your assigned location for light duty. That would be the perfect opportunity to send them a certified letter for their refusal to come in and lay it out that you have light duty for them, it meets their restrictions, they are refusing to come into work and refusing to respond to your messages for correspondence, and you're telling them up front in a legal form that you are accepting their resignation. Make sure that in these letters that you send, you don't say terminate, you don't say discharge, you say we are accepting your resignation. And what this does for you is it allows you to control the message. It allows you to control how this is going to be framed, because you're putting in writing in a certified manner that you've made attempts to correspond and communicate with them, and it is them and through their actions who are preventing them from keeping their work, from preserving their employment. So it frames that in a manner in which you can then prove to the state and to anybody else that you made attempts to help them preserve their work if they chose to avail themselves to the accommodation. Allow the employee to fulfill their notice period. Some states are going to penalize you if you do not allow them to fulfill their notice period. All bets are off on this if you pay them, okay? So, for example, the employee gives you 30 days notice. They have been a pain in your neck for forever. You don't want them in the workplace, or maybe there's a good business reason for them. Maybe they handle sensitive information that you don't want them to have access to. They don't have to work, but you do have to pay them. So you can tell them, we'll honor your 30 days notice. You don't have to come back into work. We'll pay you. That will remove that issue. If you choose not to do that, most states have a hybrid system in which the period in which the notice would have occurred, say for 30 days, and they file unemployment, they may be awarded the unemployment for that first 30 days as a discharge because you refuse to allow them to work their notice period. After that 30-day period, then the resignation reverts back to a resignation. So you're potentially exposing yourself to 2 or 3 weeks of unemployment in that scenario based on the fact that you will not allow them to work, to fulfill their notice period. You may also, if you want them to work, but you don't want them in the same position, you may reserve the right to transfer them to a position outside of their normal duties for the notice period. So as long as you don't cut their pay and cut their hours, you can put them in the corner inventory and office supplies for those 2 weeks or for that month or whatever it might be if you want to use that angle instead. Save all forms of communication, okay? We have protested and prevailed and obtained disqualifications on resignations with everything that's listed here. Email, text messages, social media posts, you name it. We've had people who have posted on their Facebook, I'm gonna tell those so-and-so that I'm quitting, and I'm gonna go in and tell them off and all that kind of stuff. We've sent those in with the letters of protest to show intent of resigning, because generally speaking, these are the types of individuals where you're having a conflict with them. They're the ones that after they resign and they don't give you the letter of resignation, and a certified letter is really not going to be a useful tool for you, those are the ones who go down and they tell the unemployment office that they were fired, okay? Their convenient amnesia kicks in. So make sure that you save every form of communication you have with these people so that we can then send them in to support our assertion that they're the ones who created the separation. In some cases, a written statement from employees who witnessed the event will be useful as well, because say there's a verbal confrontation and the employee quits and you don't fire them, it's very clear they're quitting. Keep in mind they're going to go down and they're going to have that convenient amnesia and tell the employee that and tell the state that they were fired, that they don't quit. It's going to be a he said, she said, unless we can provide them with something that's going to tilt the issue in our favor. Written statements from other employees who observed it would be is very helpful and very useful. Whenever possible, control the message, okay? Make sure you always use language that clearly identifies the voluntary nature of the separation. There are lots of times where employers unintentionally muddy their issue by using language that they think is neutral. Anything that implies that you fired the employee, words like terminated, discharged, ended, whatever it might be, anything that implies that you decided that they weren't going to work for you any longer is going to be construed by the state as a discharge. Always work in the language that they voluntarily chose to separate from you, okay? Make sure that you use that language and make sure you frame it in your documentation, your internal notes, whatever it might be, that they are the ones creating the separation by voluntarily choosing how it ends. Finally, Resignations in lieu of dismissal will not be considered voluntary resignations. Those are always going to be, they're constructive discharges is what one of the popular terms for them are. All the states are very clear. It's gone all the way to the United States Supreme Court that for it to be voluntary, it must be conducted by the claimant. In a case of resignations in lieu of dismissal, they have no choice in this matter. They are not going to work 1 minute past the end of that meeting. You're just allowing them the opportunity to show how it shows up in their employment file. So in those cases, even if they write you a manifesto, it's not going to be considered voluntary resignation. Because again, remember, they're going to go down to the unemployment office and they're not going to say that they quit. They're going to say that they were forced to quit. So control your message in those cases as well. If you're going to fire them, because this only muddies the issue, because in your eyes, generally speaking, employers say, well, they quit, and they tell us they quit. And then we tell the state they quit, and then we have to backtrack a lot of times by going back and saying, no, it was a resignation in lieu of dismissal, and here's the reason why you're going to fire them. Remember, unemployment is a game of credibility. When we start on one path and we have to retract our original argument, that hurts our credibility. So go ahead and control your message whenever possible. So with that, I think everybody knows who UIS is, but you know, we're a third-party administrator, and we'll update this for 2016 when we get the final figures in, but we have a pretty good disqualification rate for all of our clients. So any questions, you can type them down there at the in the bottom there, and we'll answer them as we need to. All right. Well, if there's no questions, we can go ahead and appreciate everybody participating. If you have any questions, our phone number is 816-524-5999, and my email address is jo@uiskc.com. That's jo@uiskc.com. We appreciate you all participating, and we'll be sending out a recording of this to everybody who registered. So thank you again, and we will see you at the end of February.